in our fifth lecture on intellectual property right, and that in particularly relating to this landmark case, Mars and vs. Glenmark in 2015 will make a critical review and particularly two different named medicines, Januvia, then Janumet, as made by Morshoff and Dome, that manufacturing and marketing issues relating to this diabetes medicine and the very patent number that was 209,801 6. So it was in particularly regarding the sitagliptin phosphate and the monophytate and the metformin hydrochloride as with reference to section 3 subsection D and section 64 subsection 1 clause F and clause G. So, in that connection, we discuss in detail section 2 of subsection 1 and clause A and section 2 subsection 1 clause AC and section 83 of the Indian Patent Act 1970. So, here the very respondent had been restrained with a permanent injunction. So, in detail, we would like to discuss the very judgment in 2015 in this landmark judgment, Mars vs. Glenmark, was delivered by the Delhi High Court, where the Honorable High Court issued a permanent injunction against the defendant, that was Glenmark, preventing it from manufacturing and selling generic versions of Merck's patent anti-diabetic drugs, Januvia and Januet. The judgment addressed complex patent claims, contentions regarding inventive step, industrial applicability, and the sufficiency of disclosure, ultimately siding with the plaintiff or the petitioner Mark. The court clarified that the burden to prove obviousness lies with the defendant and discussed the very relevance of public interest and affordability under patent law. That decision underlines the court's discretionary powers in patent revocation and demonstrated the very impartial application of Indian Patent Act of 1970 despite criticism from generic drug manufacturers. So Delhi High Court has restrained Glenmark, the defendant, from making and marketing generic versions of Merck and Doom. The MSD insert a popular anti-diabetic drug, Januvia, which is scientifically medically known as sitagliptin, and Janumet, which was a combination of sitagliptin and metformin. In its radar dated 2015, as it was delivered by the Delhi High Court, the arrest and Glenmark, the defendant, from making, using, selling, distributing, advertising, exporting, offering for sale or dealing in sitagliptin, phosphate, monohydrate, or any other salt of sitagliptin in any form, alone or in combination with one or more other drugs, or from doing any other thing that infringes the very claimed the subject matter laid down by the petitioner or the plaintiff marks regarding Indian patent number that it was having 209,816 granted in 2017. So the very facts that was raised by the plaintiff or the petitioner that Marks Pharmaceuticals Private Limited, which obtained patent number 209,816 in 2017, has 20 claims and it covered by claims 1 to 3, 5 to 10 and 14 to 17, and sitagliptin is specifically claimed by claim 19 of the patent suit. So keeping in mind the public interest, Januvia was launched in India with a price tag of Rs 43 for fill, which is roughly one-fifth of its price in the United States of America. Bulk packs of Januvia were imported from Italy and were sold by the Merck Pharmaceuticals Private Limited. The Merck Pharmaceutical Private Limited have also launched patent access program under the name MSD Sparse Helpline, which was the first of its kind in India. Objectives of this program was to facilitate optimal and comprehensive management of patents with type 2 diabetes mellitus by improving patients' understanding of the disease and its management, patients' adherence and compliance to prescribed therapy, and patient self-involvement in the disease management process. The defendant or the respondent Glenmark manufacture cells offers for sale and advertises the pharmaceutical compositions about sitagliptin phosphate monohydrate under the brand Gita and sitagliptin phosphate monohydrate and metformin hydrochloride under the brand name Gitamet. These were the generic versions of Januvia and Janumet. So, now we would like to discuss the very contentions of the defendant, and that was Glenmark. Products that were marketed and sold by Glenmark were not covered by the very suit filed under the patent law. Suit patent disclosed the products sitagliptin, hydrochloride, whereas sitagliptin phosphate monohydrate was a different chemical entity having different physical and chemical properties. Products disclosed in this patent suit are not capable of being administered as a medicine, as the same are chemically and physically unstable in nature. So, as laid down, the contention of the defendant, Mark, the plaintiff, did not pursue the very application in respect of sitagliptin phosphate monohydrate in India and voluntarily abandoned the same, thus resulting in sitagliptin phosphate monohydrate being in the public domain. The plaintiffs did not approach the court as it was the contention of the defendant with clean hands and have suppressed material facts. Further, the defendant made the contention that generic drugs Zeta and Zetamate are beneficial to the public at large because of their low cost. Further, in this light, the mark the petitioners had been overcharging the Indian customers by charging the same price for Janumate and Stamate, regardless of the potential and strength of the tablet. So, in the very counterclaim, here Glenmark prayed for revocation of the patent suit on the grounds that the invention lacked inventive steps within the meaning of Section 64, subsection 1, Clause F of the Patents Act 1970 and was obvious to a person skilled in the act. Further, the invention claimed lacks industrial applicability within the meaning of Section 64, subsection 1, Clause G of the Patent Act of 1970. Further, the contention was regarding disclosure was insufficient within the meaning of Section 64. Subsection 1 clauses as complete significance was not disclosed regarding the preparation of sitagliptin base so as to enable a person in India possessing average skill and knowledge to work the invention. So the disclosure in the patent suit were extremely broad. Further, it was contended disclosure, and in particularly the very patent was obtained on a false suggestion or representation. So, the petitioner, Merck and Company, deliberately did not disclose the subsequent application filed by it for the dehydrogen phosphate salt of sitagliptin, along with its crystalline forms, both hydrate and anhydrate, before the patent office. So, replying to that, the contention of the plaintiff was that sitagliptin in all its forms and salts, including sitagliptin phosphate, are covered by claims 1, 15, 17, and 19 of the patent suit. The therapeutic made in Januvia and Janumed is sitagliptin. Suit, that patent suit was the basic patent for sitagliptin and its pharmaceutical acceptable salts in all its forms. be it chemical or physical. Phosphoric acid is disclosed as an acid that can form a salt with the sitagliptin free base, and hydrates are also disclosed in the specification. One skilled in the art would know how to make the dihydrogen phosphates salt from the hydrochloride salt, and the further contention by the plaintiff that in India efficacy is restricted to therapeutic efficacy. Therefore, such technical advantages were not sufficient to protect the invention as it was claimed from the prohibitory ambit of Section 3, subsection D of the Indian Patent Act. So, here the court found that and noted that the onus to prove that the invention in the patent suit was obvious to a person skilled in the art rested on the defendant, and the defendant, Glenmark, in this case had failed to prove the same. So the Honorable Court said that mere comparison of chemical structure is not sufficient, and neither is speaking of parts of chemical structures of different patents and clubbing them sufficient to prove that the innovation or invention is not novel or obvious. The defendant witness in this case was said to have followed a methodology referred to as hindsight analysis, which was a prohibited methodology in patent law. Upon questioning that fact, the defendant's witness reserved his comments. The Honorable Court felt the need to reiterate the reading of Section 2, Subsection 1, Clause A of the Patent Act 1970, which defines invention as a new product or process involving an inventive step and capable of industrial application, along with Section 2, Subsection 1, Clause AC of the Patent Act, according to which capable of industrial application in relation to an invention means that the invention is capable of being made or used in an industry. Another section that had claimed significance in that judgment was none other than Section 83 of the Patent Act 1970. The very Section 83 revealed that when an invention is said to be capable of being made or used in an industry, such an invention should benefit the public and should be affordable. While answering the very issue of infringement, two things that the court observed to be relevant were that 1. Sitagliptin is the molecule with the therapeutic utility, whereas sitagliptin phosphate monohydrate has advantage over the sitagliptin free base in that it had got weight or physical and chemical characteristics so as to make it in tablet forms. On the issue of lack of sufficient disclosure and broad claiming, the court in that case, and that is relating to Merck vs. Glenmark in 2015, had observed that the disclosure in the very patent suit was not for a lay person, but was addressed to a person of ordinary skill in the art. Further, since the defendant Glenmark in itself has been successful in making sitagliptin phosphate monohydrate, it could not claim that the patent in question was too wide and broad to quote the court, as it was expressed that the defendant could not be permitted to blow hot and cold in the same breath. So the provisions under Section 64 of the Patent Act 1970 make it clear that it was not mandatory for the court to revoke the patent merely because any of the grounds as mentioned in Section 64 subsection 1 are made out. It was the discretion of the court to revoke or not to revoke in the given facts and circumstances of a case. So the word may used as in section 64, subsection 1 of the Patent Act makes it clear that it is the discretion of the court to revoke the patent under this provision. If any of the grounds stipulated therein are disclosed or made out and cannot be read as contained by the defendant. So, with respect to the very arguments made about public interest, the Honorable Court noted that sitagliptin was not the only inhibitor for treatment of type 2 diabetes in the market. There are several other inhibitors, including the one manufactured and marketed by Glenmark called tinilistin. Based on these findings, Glenmark had been restrained by a decree of permanent injunction from making, using, selling, distributing, advertising, exporting, offering for sale, or dealing in sitagliptin, phosphate, monohydrate, or any other salt of sitagliptin in any form, alone or in combination with one or more other drugs, thereby infringing the very patent suit. Several important issues have been reiterated by the Honorable Court in that case. The decision came as a big blow to Glenmark, who, according to news reports, was said to be contemplating further action. That decision, delivered in Mark and Glenmark in 2015, do not seem to have elicited favorable response from the Indian generic companies, who feel that the decision favors the multinational corporations, which is in detriment to public interest in India. However, that we have discussed in this earlier post, where we observed that the courts in India have always given decisions impartially based on available facts. As it was said, you can't possibly keep everyone happy and you have just go to realize that you can't be all things to all man. So hereby in this very important landmark decision that was delivered by the Delhi High Court, in particularly relating to generic drugs and those in particularly relating to Januvia and Janumet, why Mark Sharp and Groom. The very question was raised regarding manufacturing and marketing as the very drugs were relating to diabetes too, and in particularly sitagliptin, phosphate and monohydrate and metformin hydrochloride. And with reference to that, the Delhi High Court made reference to the provisions under Section 3, Clause D and Section 64, Subsection 1, Clause F and Clause G. Further, it made reference to Section 2, Subsection 1, Clause F and Section 2, Subsection 1, Clause AC and Section 83 of the Patent Act of 1970. So finally, the Delhi High Court in this landmark judgment delivered in 2015 relating to patent rights under Indian Patent Law or Patent Act of 1970 restrained the very respondent Glenmark with a permanent injunction